Hi, tonight I am in Hungary and it is a wonderful occasion to talk about the case law on Hungary. As you might know, I prepare the multi-billion dollars class action against the government of Lithuania in order to restitute the heirless Jewish property that was nationalized by the Lithuanian Nazi government in 1941, and we also claim damages for slavery work, torture and murdering 211,000 of Lithuanian Jews by the government of Lithuania. Hungary is extremely interesting for us because we have such a wonderful case as Simon versus Hungary that is considered by the United States courts. So last year we had a decision made by the Court of Appeals of the United States for the District of Columbia. So what does that decision say? That decision is wonderful in many aspects. First of all, I am happy to read it, and I laugh when I read it because, you know, we have a Nazi president of Lithuania. His name is Gitanas Nausėda. So he says that imprisoning Jews in ghettos and in the concentration camps, as well as nationalizing their property, is not a part of Holocaust. And this decision of the United States Court of Appeal is surprising for the Nazi president of contemporary Lithuania because it clearly says that the United States courts consider imprisoning Jews in the ghettos and in the concentration camps, as well as confiscation of their property, nationalization of their property, is a part of Holocaust. So this is a consciousness shift. You would never hear this from a Lithuanian judge. Then the order itself is on recognizing the United States as the first instance for this kind of litigation. So first of all, the Court of Appeals says that the United States Foreign Sovereign Immunity Act does not require exhaustion of the internal remedies. In other words, before addressing the United States courts for restitution of property, heirless property and damages, you are not obliged to address the internal Hungarian or Lithuanian courts. And this is a wonderful thing. The second point that the Court of Appeals makes is that it is for Hungary to prove that it would be a forum conveniensis, for this kind of litigation. So this is a reallocation of the burden of proof from the claimants to the Hungarian government. And we obviously have absolutely the same situation in case of Lithuania. And in Lithuania it is worse because Lithuania officially does not recognize imprisoning Jews and confiscation, of their property as a part of Holocaust. So Lithuania is much more Nazi than contemporary Hungary. And it also means that it is easier to win a class action against Lithuania. And finally, I love this order because it states, it justifies itself by the policy of the American government. So the decision of the United States Court of Appeal says that we interpret our legislation and the general principles of international law in this manner because this is a policy of the United States of America. If you are a descendant of Lithuanian Jews from the United States, Canada, South Africa, write me an email and join our class action. We need you in our litigation.